The Mediation Act ensures proper, smooth, and timely conduct of mediation. The Act does that in several ways. It provides a definitive start and end to mediation. It tells you when a mediation is deemed to have commenced and terminated. And more importantly, the Act provides a strict time limit to complete mediation. Accordingly, a mediation has to be completed within a period of 120 days from the date fixed for the first appearance of the parties before the mediator. The parties may agree to extend that period, of course, but only for a maximum of 60 days. That way, there is some pressure on the parties and the mediator to bring the process to close, and there is some protection against any party using mediation to delay the entire dispute resolution process. The Act also lays down the manner of conduct of mediation. The specific manner is yet to be prescribed by the regulations, but for the time being, the rules governing the conduct of court-annexed mediations will apply. The mediators, although they are mere facilitators and not adjudicators, play a key role in the proper conduct of mediation. The Act describes the role of mediators. For example, it makes it mandatory on the mediators to assist the parties in an independent, neutral, and impartial manner, and to at all times be guided by the principles of objectivity and fairness. The Act goes on to list the aspects a mediator should take particular care of during a mediation, like exploring areas of settlement and generating options, of course subject to the freedom given by the parties. Given the importance of the mediators, the Act also sets out fair provisions for the appointment, for the termination, and for the replacement of mediators, which indirectly contributes towards the proper and smooth functioning of a mediation. The Act also provides a lot of confidence and protection to the mediating parties. The confidentiality provision, that is, unless in restricted circumstances, any communication in a mediation, be proposals, counter-proposals, promises, opinions, or suggestions, should be kept confidential. Again, no mediator or a participant in a mediation should be allowed or compelled to disclose any communication in mediation, except again in restricted circumstances. The mediators are not to be presented as witnesses in other proceedings. All of these give the parties the confidence to meaningfully undertake mediation and work towards a settlement without the fear of his words or actions being used against him at a later proceedings. The Act also provides a greater flexibility to the mediators as well as the parties. The mediators are not bound by the strict procedural rules, either the Code of Civil Procedure 1908 or the Evidence Act 1872. So, I hope you can see that all of these provisions are geared towards proper, smooth, and timely conduct of mediation.